Hi, everyone. Welcome to Conversations on Data. I'm your host, Havish Madhvapati. I'm delighted to have with me today Bharat S. Kumar, who works as an associate partner litigation at Sai Krishna and Associates. He's also an empaneled counsel for the government of Delhi and CPCB. Bharat is an experienced dispute resolution counsel with over a dozen years of experience in intellectual property disputes, arbitrations, general civil and commercial disputes, human and animal rights violation, etc. What makes this podcast even more special is the fact that Bharat and I were classmates back in school, and it's a pleasure to reconnect with him once again. Hi, Bharat. Welcome to the podcast.
Hi, Avish. It's great to have you and, of course, be in the podcast.
Excellent. So, to start off with, could you tell us a little bit about your current role and your professional journey so far?
Yeah. So, Havish, I am presently working with Sai Krishna and Associates. That's a tier one law firm based in Delhi. And we've also got offices across the country in Mumbai and, of course, one in Noida. And I work with the dispute resolution and the litigation wing. To give to put it in layman's language, is more to do with court work, maybe litigation, doing court cases, if I may say so. So that's where I'm working. Additionally, I'm also an empaneled counsel for the state of Delhi, and I was an erstwhile counsel for the Central Pollution Control Board, that is CPCB. Now, our firm, if I may say so, I joined the firm close to about almost 12.5 years ago. And at that point in time, the firm was predominantly an IP firm. Now, the owner of the firm, a first generation lawyer himself. In fact, it also goes in sync with the conversations which we are going to have, believably, because it has a lot to do with startups and, of course, first generation business people, if I may say so. So the firm's owner, Sai Krishna Rajagopal, he was a first generation lawyer, passed out of NLSIU. And the firm initially started with as an IP firm, as an intellectual property firm. This is almost 2 decades ago, or over and above 2 decades ago. Then over the years, personal to me joining the firm in 2009, we've kind of transformed into a full service law firm, if I may say so. A full service law firm means probably we're doing everything from corporate, purely corporate, that is mergers and acquisitions, corporate transactions, contract viewing, contract vetting, to IP prosecutions, normal prosecution work, IP enforcement work, IP audits, and other corporate audits, and also, of course, dispute resolution and litigation. So, if I'm going to talk about my journey has been extremely satisfying. I've had the privilege of working with, probably one of the biggest litigators over a period of time, worked on multiple issues from human rights violations to fundamental rights violations. So probably fighting one of the first cases in the history of rights violations against serving Air Force personnel, which involved a manufacturing defect in a MiG aircraft on several IP issues, arbitrations. So it's been nice. It's been challenging. It's been good. I've also, in fact, being our firm's policy of giving it back to the society. Who would know it more than you, considering I've heard a lot about you doing for people and giving it back. But yeah, so similarly, we've done a lot of, our firm encourages doing a lot of pro bono work, which I've taken up. I've also been a counsel for the Delhi State Legal Services Authority for close to about 5 years, and also I Pro Bono, which is an NGO, and Trust Law, which is a Thomson Reuters organization.
Excellent. So Bharat, jumping straight into it, what are some of the common legal mistakes made by startup founders?
Okay, so moving aside from, of course, probably what they ought to do in terms of keeping their reputation clean even earlier, because I believe in the business world it matters a lot. I believe to start with on the legal issues, one needs to make certain that their documentation is in place. By documentation, what I mean is probably if you're setting up a manufacturing unit, I'm just giving you an example. So you need to have requisite clearances from probably the MCD. And why I'm saying MCD, even for manufacturing and otherwise, is because even if you're setting up an office, there has to be, depending upon the city, the state, there are clearances which ought to be required. So legal documentation has to be up to date. Permissions have to be up to date. That's point number one. Which I feel that ought to be done. And you must not make a mistake when it comes to something like this. Second, if I may say so, is that you need to your IP, that is an intellectual property. By intellectual property, if I may break it further, and this is only for the clarification of probably the audience, you know a lot about it because you've been working on it, and it's divided further into IP is divided into trademark, copyright, patents, designs, and so on and so forth. So it depends on what the organization does. Now, to elucidate further, tomorrow, if, for example, a startup comes up with a brand name, that brand name is also registered. It is to be registered as a trademark. It can be registered as a trademark. Like, for example, Infosys is registered. Services with Infosys providers also registered. So long and short of it, not registering your IP, not registering your trademarks. Copyright is not registrable. You can do it if you want to, but even if you're into patents, if you don't do it within time, your competitors might eat it up. So that ought to be registered. This is something, there has to be no delay in that because you don't want any litigation. This is one of the few. The third is probably non-compliance with security laws. Now, if I may security laws, if I may say so, would be probably the shared swap agreements, probably the share agreements, any ESOPs, everything has to be cleared, regularly submit to the MCA. Those requirements have to be complied with. Fourthly, if I may give an example now, you've heard of POSH, I'm very certain, everyone must have heard of it, Prevention of Sexual Offences Against Enhancements Against Women. There's an act to that effect. There are also labor laws which need to be complied with, considering you have manufacturing unit or otherwise. Now, when I'm saying manufacturing units, for example, a manufacturing units, for example, an HUL would have to probably make certain, just to elucidate, be like you need to have like washrooms in place, you need to have everything in place in terms of cleanliness, urinals, and so on and so forth. For example, these are, I mean, labor laws are wide. It's like a sea. So I'm just giving you an example. Now, if you go on further with probably POSH compliances, then that ought to be made, because if you have an organization which has more than 10 employees, now if there is a startup, there has to be I mean, it just so happens that your employees multiply, I mean, it just goes on and it booms. So you need to make sure that you are compliant with the POSH laws, because irrespective, now this is necessary, irrespective whether you are female or not, 10 or more employees means you need to make sure that you have a committee and you are relevant, the compliances are in place. So to name a few, I would say these are extremely necessary, I mean, issues. And if you don't comply with them, now this is broader. Now, when you go further, MCA compliances, MCA means Ministry of Corporate Affairs, that needs to be looked into. As I mean, if you have, for example, if you're registered as a company, that's a separate issue. If you're registered as like a partnership, the registered partnership is different. You don't register it, there are different implications. So these are mistakes depending upon what type of businesses you do. You need to be compliant with them.
Got it. So I have a follow-up question to that. So you mentioned in your answer everything from partnership to being a self-proprietor to starting a company. Now I have basically done everything, right? So I have worked with a startup with having absolutely no contract in place. We started a private limited, and I ended up being a proprietor. So how does an entrepreneur decide which is the correct path to pick? And what would be the advantages and the disadvantages of picking each one of these?
Okay. So LLC as a concept, if I may say so, came in very recently with the acts. If I may say so, there's something known as an enactment, that is an act which came into play, the LLP Act. And the reason why probably people chose LLC, what I'll do is I'll start with probably a partnership firm. I mean, I'll just define it as how it is. To give an example, tomorrow, if you and I think about starting something on our own, so then in that case, our immediate goal would be probably to establish a partnership between the two of us. We'll draw out an agreement. Now, when we go further, the difference between a registered partnership firm and a non-registered partnership firm, and then eventually I'll answer the LLP question also, because this flows through that. And a partnership firm, if I am not registered, if you and I start a partnership and we are not registered, then in that case, and like a massive negative would be, in addition to certain other issues and which may eventually come up, it could also be that we can sue a third party. Now, why this is one of the biggest negative is because if we do start a business and we are not registered, and tomorrow we have a dispute with a third party who is a vendor or probably whom we have a joint service agreement, then we can't initiate any proceedings against the entity, and this is a negative. Now, coming back to the second issue, that difference between a registered and a non-registered partnership firm, I certainly do believe that one must register a partnership firm because it gives you some bit of additional rights. You obviously can sue a party, and then it also gives you a lot of these rights wherein if you go for probably credit to a bank. So solely being a non-registered partnership firm I would say you'll be on a like a weak footing, if I may say so. So you must register a partnership firm. Now let's come to the third point, an LLP and probably something. Now an LLP, if I may say so, is in fact a little different from a company. And of course, if I may put it like that, it's more closer to a registered firm. LLP is also dependent a lot on how much your cash flows are. Now, there is also something which is incorporated saying that a small LLP is where, for example, a 40 lakh amount is your cash flow. It can even go to 5 crores. That can be a small LLP. In comparison, if one registers a LLP, if one is registered as an LLP, and of course, probably not as a company and a partnership firm, then you have more flexibility. You have relatively lesser requirements in terms of compliances in comparison to a company. And of course, the business model is the former business model is also more relaxed, if I may say so. If the difference between an LLP and a traditional partnership firm is that in a traditional partnership firm, that is a non-registered partnership firm, if I may say so, every partner may be jointly liable. Now, LLP, on the other hand, works as as a dignified partnership structure, if I may say so, and it's an entity by itself. So it's not that every partner might be liable. It's the entity which will be liable if there is any if there are any proceedings to be initiated. So coming back to your question in hand, registration of a partnership, of course, yes. LLP is preferred because it gives you some bit of legal sanctity, and it gives you a lot of legal protection in terms of how you can initiate proceedings, how you can go on and have contracts with someone else, and so on and so forth.
And what about being a proprietor?
Oh yes, I'm sorry, I missed that. So a proprietorship firm is of course permitted under law. And if it's a non-registered proprietorship firm, see, so I'll give you an example. A partnership firm can be of two types. It can be a proprietorship firm, or it can also be a non-proprietorship firm. By non-proprietorship firm, what I mean is that like you and I start a partnership. You and I are probably 50% holders. So we are equal holders. So it's not necessarily a proprietorship firm. If there are more partners with kicking, for example, if we have 4 or 5 partners kicking in, then we are equally, like for example, at 20% stake each. So it's not particularly a proprietorship firm. Now, in a situation where it's a proprietorship firm, there are also like for example, there is no equity which you ought to give to someone else. If it's a registered proprietorship firm, then it's something else. Your compliances are different. And as I'm saying, it's always better to have your firms registered because that gives you a lot of legal sanctity. The buck stops on you if it's a non-registered proprietorship firm, because at the end of the day, you're the person who's solely liable. So you as a proprietorship firm, the owner is the proprietor and the owner are the same. Like for example, if you start a firm, so you are the sole owner of that firm. That is how it is seen. So no one else, if I may say so, has the power to veto what you are saying because you're the boss. That's how it goes.
Got it. So I want to talk about the enforcement strictness of copyright and trademark. So I'll give you a use case. Now, I work as a vendor for a number of clients. Some of these are very large companies. So let's say the top 500,000 companies in the country. Now, payments are always a sore point, right? And for small vendors where the payments are not that frequent and the amount is not that large, it's understood in the industry that especially as a newcomer, payments are going to be a sore point because they might say a T plus 30 or T plus 45. But then you really have very little say in that. You know, if the client decides to pay after a while, there's not really much you can do about it. Now, what is ironical is I'm okay with that. You know, I have learned, having done this for a while, that I know how to manage my cash flow, and I understand it might take, let's say, 3 months or 4 months. But, you know, I always find it very ironical that the contract as such seems very rock solid. You know, on the contract from both parties' perspective, it clearly says that, you know, there is an NDA that I have to adhere to as a vendor. The party will be paying me, let's say, 15 or 20 days post the date of invoice. But then it doesn't ever come on time, right? And I just wanted to understand that one is that why is it so? And is it really because companies understand that these small vendors will not really have much to fight against? Also, in terms of let's say a chance where it's a big payment, and the client refuses to give that payment, what is the right that we have?
Okay, so as you were mentioning, let's just start with let's just start with the very inception of you and someone else's business relationship. You start with a contract. Now, law does not differentiate between you being a small entity or someone else being a small entity. As long as the contract is drawn in and there are deliverables under the contract, you ought to deliver. That's point number one. Now, point number two is if a contract is drawn and there are, like for example, there are deliverables to be mentioned which are to be delivered within a particular point in time. At 15th of every month, 30th of every month, the payment has to come forth. So that payment has to be made, that has to be honored. Your remedies to that extent would be, irrespective of whether you're a small organization or not, is that you need to make sure that your correspondences. Now, why I'm saying is because this, of course, when it comes to legal, any litigation which one files in court. So you must make sure that you have all correspondences in place. You have invoices issued at time. You have follow-ups done. Now, why this is necessary is because tomorrow, if you'll approach the court of law, you'll say, now let's just come. In fact, there's one point which I missed. The general concept, the general misconception, if I may say so, that legal remedies are not. It doesn't come fast. Which to some extent, if I may, it's true and untrue because there is a diversification which has now been done in terms of commercial suits under law. And I'll tell you where I'm coming from. Is because under commercial suits, the remedy is time bound. Now, the courts, the very reason why the Commercial Court Act was established, wherein all of these issues, which, for example, a contractual issue or even a IP issue, an intellectual property issue, there are various issues which are defined under Section 2 of the Commercial Court Act, which are termed as a commercial suit. So, a commercial suit is an expedited remedy process. Courts are also bound. There is no time frame, if I may say so, because it's of course stretched. The act mentions the time frame. It's a tax stretch, but it's not how it used to be earlier. A lot of our disputes, which are if it be a contractual dispute, if it be something else, if it's a commercial suit, then the hearings come faster, the dates are short. That's one point. Now coming back to what you said and how that this goes in sync with that is, irrespective of whatever the size is the entity is, you are bound by a contract. You have to deliver by that. What the smaller organization needs to make certain so that they are not oppressed is that, like I mentioned, there are correspondences, there are follow-ups being done. Everything is drawn really well in the contract. By everything, what I mean is the time schedules. If you are an MSME or other smaller organization. Now, a lot of people don't know why I'm saying this is because is that, like for example, an MSME, the payments are time bound. RBI even gives like a particular percentage of interest which ought to be given if these payments are delayed. So as an MSME ought to be registered. I'm just giving an example. And as a SME, your rights differ depending upon whether you're a small organization or an MSME and so on and so forth. That said, your remedies in court particularly flow from a contract. If timelines are mentioned, it will go under a commercial suit. I usually advise people to make certain that you have an arbitration clause also, because arbitration though are a tad expensive, but I would say they are faster. You'll get an arbitration remedy within 6 to 8 months. And then as it goes, even if the other entity probably appeals, your chances, if it's a well-reasoned order by the arbitrator, it becomes very less at the upper stages to retain. Eventually, you get that money. But that said, long and short of it, your contract has to be rock solid. Arbitration clauses have to be mentioned. Do not make the mistake of putting your jurisdiction of a dispute. Jurisdiction, what I mean is, if you and I are, you are very aware of that. If you and I are there in a contract, so make certain that jurisdiction is not some random place which benefits the other party, but probably a neutral place, or if it benefits you as a smaller organization, probably your place. That's much better is how I would say so. So that's how you ought to draw. Law, again, I'm repeating, does not differentiate between a smaller entity and a larger entity.
Right. So that's helpful to know. I do have a small follow-up question on this. Now, what happens is that so I typically sign, let's say, the NDA with my client. Then we sign a contract for 12 months, which lays out the scope of work and the payment terms, right? Now, what will happen is that they will typically never amend the contract because it's too much hassle for them. But it will follow through in an email trail or, let's say, WhatsApp communication, where the business leader is saying that the scope of work has expanded, right? Now, for example, if we were supposed to do 100 and it expanded to 110, and I'm okay with that, at least in the way we are communicating, I'm okay with that. But they end up expecting 150. Now, what happens is that, so the question here is that what do we do? What resort do we have? If the client is expanding on the scope of work in a communication other than amendment of the contract, is that legally bound? Does it hold any value if it's on email or on WhatsApp?
I'll tell you. So WhatsApp in terms of how the Supreme Court has gone through in terms of WhatsApp communications, it's been a for and against also. So earlier Supreme Court said that WhatsApp communications are they can be admitted in court, then eventually they said they're not. So I would rather say instead of WhatsApp, if you're an organization, you must make sure that you have emails and email communications because that comes in handy in court. That's always acceptable. That said, by what you are saying, in such a situation, as I would say, can you just repeat? I'm so sorry, I missed that part. Can you just repeat that?
Yeah, so I just want to give a clear use case. Let's say that I was expected to deliver something on the 15th, right?
I'm getting it. Yeah.
And the client suddenly texts me in the middle of the night saying that I want it on the 13th, right?
You don't want an addendum.
Now, yeah, and I'm okay with that. But then usually what I do, Bharat, is that I will send out an email telling the client that we spoke over WhatsApp.
Yeah.
And then you mentioned that it was supposed on the 30th to be given on the 30th. Now the client
I
typically will never acknowledge that. So my question also is this, I guess is a different question. My question also is that if the client refuses to acknowledge, does it still have value?
So you must make sure that he acknowledges it. Okay. And why I'm saying is because tomorrow he may say that I never gave you an assent. That said, you must also put it very clearly and unequivocally that our contract scope extends to this.
Okay.
If I'm doing this, do you suggest we should add it as a contract, or would you look into my remuneration or my compensation, which ought to be looked into? Okay. If you feel touchy because probably you don't want to lose a bigger client, then in that case, you must make sure that you must make a line over there. This is beyond the board scope. It'll be great if we can work it out together, or probably on a later date, so that it at least comes through. But that said, if you're looking at monetary compensations owing to the contract and you working extra, that will not happen till the time you do not put it in the email or it doesn't come into writing. So yes, the contract has to acknowledge, the other side has to acknowledge that. And of course, it has to come out very clear, is what I'm trying to say.
Okay, got it. I want to talk about starting a firm. So, I mean, let's say there is a set of students who want to start a business and they decide to start an undertaking. The question here is, should they get legal counsel right from the beginning? Should they spend an X amount of dollars and keep that on their side right at the beginning, or should they sort of wait for a while to get some cash flows coming in? Because what happens is that I have realized from experience, when you need it, it's probably too late, because there are so many questions in your mind and then you have to go running here and there. I mean, nobody expects things to go south, but when things go south, they go south.
I understand, yeah.
So as a business, could you also share a little bit about the commercial in terms of how much minimum money should a startup expect to spend to get maybe some basic legal counsel that helps them in the moment of need?
So if you're asking a lawyer whether a lawyer should be recruited or not, of course I'll say yes. So I mean, that's definitely yes. But then, yeah, on the reality aspect, I know probably where you're coming from. I very strongly do believe, Havish, that this is a personal call. Now, that said, it depends completely on how big an organization is, what are the cash flows, whether an organization can afford an in-house lawyer, or alternatively, probably having a lawyer or a law firm on this thing, on their retainer. But I would strongly suggest that for something which entails if I may say so, purely a technical legal issue. So some type of an opinion ought to be taken. And for, of course, like the earlier questions which you had mentioned, that is it that you need to comply with something? So there are many compliances with company. Like, for example, even if it's a LLP, registered, non-registered partnership, I would suggest anyone, so that I would suggest that, I mean, coming back to the partnership ought to be registered. But then coming back to this, keeping a law firm on a retainer or lawyer retainer is advisable, because then you have a person on your beck and call to make certain that that person does your job. But if the organization is way too smaller and then cash flows is probably a problem, then of course a quick resolution from the lawyer saying that this is my problem and you need to address this is of utmost necessity. That said, one of your issues which you have mentioned about probably the monies which will be charged by a lawyer, that completely depends on the lawyer, the type of lawyer. It's exactly how probably other professions are. It's how doctors are. Someone charges you probably 500 for an appointment, someone will charge you 1,000, 1,500. So it completely depends. But one thing which I would want to make certain is that depending upon the type of requirement of a lawyer, like for example, there are many, I'm just giving you an example. Now, there are a lot of these crypto companies coming up, CoinDCX, and there are many other companies which come up. WazirX is there. So this requires a specialization. So a lawyer which has some bit of expertise in that particular area should be considered. It should not be a general lawyer, because then it might just be, see, I'm not kind of questioning someone's acumen, but then someone who's done that work earlier would be more of a use than someone who's not done it in trying to save money, is what I'm trying to say. So yes, a specialized lawyer in that field is, I would say, one should go for that. I mean, depending upon how the equation is with the person, whatever the lawyer would charge is completely on a mutual basis. There's no set fees for that.
All right. So my second last question is about tackling issues around data theft, cybersecurity, and things like that. So, as a large organization, do you hire separate lawyers for that? I think you partly answered that, in your statement. But then, how is the legal fraternity sort of rapidly gaining all that knowledge? Because there's just so much happening, right? And I always believe that the pace at which technology is changing is more rapid than the pace at which people are knowing what to do with it, right?
Yeah.
And how to consume it. So, from a legal standpoint, how is it that lawyers are sort of keeping in pace with everything that is changing? And is there like a subsection of lawyers that handle all of that?
So, Havish, what happens is, I won't say it's a subsection of lawyers, but then, like I said initially, we started off as a purely an IP firm. Now, why I gave that, why I mentioned that categorically is because even till date, a lot of lawyers, a lot of law firms are super specialized. They run boutique firms. Now, that said, data theft, in fact, if I may say so, offenses and issues which relate to cybersecurity and cyber issues, if I may say so, are to a great extent very, very prevalent these days. A lot of these lawyers, particularly, are super specializing in them. And of course, it's become a day in and day. If you'll go to any of these courts in Delhi, you'll see a lot of these issues which pertain to data thefts and cybersecurity. In fact, I am myself, I'm kind of into a number of these issues. So coming back to what you mentioned, if I may say, I'll divide it into two parts, what you asked. And one is that the preemptive aspect, and subsequently the remedy aspect. The preemptive aspect probably could be that you must have dedicated servers. It depends completely on what type of work you're doing. And of course, initially, if money flow is a problem, then that not be done. But if you have some bit of money flow coming in, then you need to make certain that you have dedicated servers. You have proper organizational emails. You're not reliant on probably a Google email. That's how I'm trying to say. It should pass through a server. And of course, laptops being given to employees. Now, why that is necessary is because if these issues with respect to company laptops, dedicated email servers, and of course, organizational emails are placed in, for any employee to steal data and to use it thereon, you are probably the owner of that organization or the IT team will get some bit of an maybe a message or an email saying XYZ person has pulled out data from the laptop. So that's a preemptive way. That requires a little bit of an investment. That will cost close to, but I think depending upon the organization size, anything between 1 and 5 lakhs. But that's a foolproof method. Tomorrow, if it goes to the court, then of course it kind of seals your case. That said, why I emphasize on this is proof has to be given, as you're aware, in a court if there is a breach. Now, coming back to what you mentioned in terms of remedy, the second part is what I was harping on. In a data theft, an organization has a remedy of both a civil and a criminal remedy. Now, by a civil remedy, if I may elucidate further, the simplest remedy which one could have is that they can file a suit for probably infringement of IP, intellectual property, depending upon what IP it is, of data theft, and of course of restraining. That is injunctive relief. That's how we say in law. So by injunctive relief is, if, for example, Havish is if his employee has stolen his data and he's gone out and Havish is aware about it, that he's stolen his data beyond his knowledge, then in that case, that suit is filed. Havish will go to the court and he'll say, okay, you must injunct because I own this data. This is the proof which I have. This is an ex-employee. So the court will give you a restraining order. That is an injunctive order. That is an order 39 rule 1 and 2 application which you file. And then the court will stop him from further doing it or further spreading it. If he still does it, then it's a contempt of court and a breach for the injunction is how it comes through. This is the civil aspect. Now, one more thing, I'm so sorry, I believe I missed in the civil aspect, is that there's also damages which comes in. So eventually, as the suit progresses, you're able to prove your case that this person has stolen your data and there's substantial harm which has come to you. So your suit for damages, that's a final remedy, subsequent to evidence coming through, also comes in and he is liable to pay some bit of monies to. So this is all in all your civil remedy. Your criminal remedy over here is that in cases wherein data theft is there, the employee is liable not only under the IT Act, the various provisions of the IT Act, but also under the Indian Penal Code. Like, for example, if it's a theft under Section 378, he is liable. If it's, for example, you had entrusted the employee with certain data and he's made use of that and it's given to someone else or he's sold it, that means a criminal breach of trust. So that also is punishable under the IPC, Indian Penal Code. So this is the criminal offense. In such a situation, what you'll do is, depending upon what type of remedies you're seeking, if it's over, for example, hypothetically, over 2 crores, you would go to the EOW division in Delhi and you say, okay, this is what has happened. They'll initiate immediate inquiry and they'll take it further. If the police does not act, you still have a remedy of approaching the courts through a different method, wherein you file an application to the court under Section 156(3) of the CRPC, subsequent to you approaching the DCP or the SP of that area and saying that the courts, you will say that this is how my data theft has taken place, so you must register an FIR. Now, why I said this is criminal is because once the FIR is registered, then the police personnel would be live. He'll have to investigate the offense, and of course, the criminal machinery against your ex-employee or the person who's stolen the data kicks in. So it comes as a deterrent, if I may say so. And eventually, as the criminal proceedings progress, there's also relief under criminal law, that is damages, if I may say so, in simpler terms, which is available. So this is a civil and a criminal remedy which is there. So preemptive, and of course, if like I mentioned, in terms of whatever you have to take care of the organizational data, and this would be, if it's violated, then you'll do this.
Got it. Got it. That's very helpful. One question got left out. So let's say I have an NDA with a client where it clearly categorically mentions that the client cannot share any data with me beyond the top 5 rows. So let's say there are 1 lakh records that they have on an Excel file. They're not allowed to share more than 5, right? I sign it and send it back to them. Now, what Bharat typically ends up happening is that some of these clients might end up giving me 10,000 rows. Now the question is,
some of these clients may end up giving you
might end up giving me more than what is mentioned in the NDA. So the NDA states that I can only get 5 records, but I end up getting 10,000 records from their side. Now the question is, can I be held accountable for it? Because I was not the one who seeked it. I'm not the one who stole it, but I'm still the recipient, right? So what should I do in such a case? Even though in my years of experience, I never had a problem, but I always feel very fearful because I don't want to be in a position later wherein somebody asks me a question as to why did you work on it and why did you not, flag it if this was what happened. And this trust me, happens like 9 out of 10 times. I won't take names, obviously, but some of the largest firms, they have these very strong NDAs, at least on paper. But when you actually start working, you realize, at least in the Indian context, that clients are so happy, willy-nilly, they'll start sharing files with you. And then I'm always a little unsure what to do about it, right? So I just wanted to take your input on that.
Okay, so if any document has been shared with you, purely from a criminal perspective, if I may say so, which is beyond the NDA, that means the client is, okay, tell me something. So when the client is giving you all of this data, I believe this data is interrelated. Like, for example, the need for a document which is not mentioned in the NDA would be also, that document and the document which is mentioned in the NDA are interrelated, isn't it? Why would he give you something which is not interrelated?
Yes, it is absolutely related. Let me give you an absolute example that happened. So I was working with a client a few months back, and I was working with a CHRO, and we were working on a compensation and benefit report. So we wanted to look at the CTC of all the employees in the organization. Now, what was supposed to be sent to me was sanitized data. So the CHRO told the business partner that you modify the numbers and send it to Havish so that he can work with the dummy data and come up with the analysis. Now, what the HR business partner ended up doing was they sent me the raw file. Now, the problem is that now I'm privy to the cost to company data for everybody across the organization, right from the directors to the bottommost executive, right? And this is like really, really sensitive data. It is so sensitive that even within the organization, everybody does not have free access to it.
Yeah.
Now the question is, can I be held accountable? Because I did not seek it. I did not ask for it. I was only the recipient and somebody sent it to me without me asking for it.
So, in such situations, tell me something. That did your contract mention anything else in addition to the like for any data which is shared? Is there a clause to that effect?
See, it would be very seldom that a contract would mention this in such detail because there will be numerous data sets, right? So it's almost impossible for a contract to account for every one of these data sets. The
So
contracts
if,
are mostly
yeah.
blank contracts. They're open-ended blanket contracts where they just mention that no data shall be shared or no sensitive data shall be shared.
So then that means you're covered. So then in that case, when it says that's what I wanted to ask. So if it mentions no sensitive data, long and short of it, what they are saying is everything, if I'll be very blatantly honest, anything which we are sharing is sensitive in nature. So you must not share it further. So irrespective of that it's there within your like strictly within your work scope, if that that word, that those terms non-sensitive data or company's data ought not to be shared, for example, it covers everything. That is how it is.
Okay. All right. Perfect. So final question. We were in school together. We have about a dozen years of experience now. I would not like you to speak as a lawyer, but I would like you to speak as a professional who has done different things in their career. And we started out wanting to do something, we ended up somewhere else. What would your advice be to college students? So I'm talking more about business school students, but I do teach a fair bit at engineering colleges as well. So let's not get into the subject that they are studying, but a general advice in terms of somebody who has experience of being there, done that, making mistakes, learning from it. What would be your advice to students, living in this day and age? They'll be graduating in the next couple of years.
So we'll divide it into two parts. One would be you as I see you, and the second would be probably me as I perceive myself. When I look at you, for example, and this is purely for college students whom you probably would be approaching, is that I've seen you starting of your own venture, which not many people do. And by the grace of God, you're doing well. You've gone into various areas. You're doing something which for a lot of people, it's only what they dream of. So long and short of it, what I'm trying to say is, don't get into the strongholds of doing a job if you have a good idea. It doesn't mean that you just come up and start selling anything and everything and start doing anything and then say, okay, I'm not successful. You must try out anything and everything when you have a definite business idea, work towards it, put an effort as how you have put it consistently, master the art of what you're doing and start your venture. Do not, the very fact that probably you don't have money flows coming in for some time should not stop. Of course, if there are personal, if one is bound by some personal issue and then one has to work, it's a separate issue. But if one has an aim, as I can see you perfectly as an example, one must take it up, not stop. Now, coming at me, like considering that I believe you've seen me because I've taken science in school. Not that I aced at it, but I was rather a bit at that age. You don't know how to and what to do. So looking at myself, I feel I've done what I probably wish that I did because I wanted to get into litigation always. I mean, after school is what I'm trying to say. I never wanted to into corporate law. One of the things is that I just had that hunch that I wanted to do something which is more related to public issues and then a lot of public dealing and so on and so forth. So if I may advise college students, just listen to your heart. Don't go behind money at the start because though packages may look lucrative, eventually when you start working, you do realize that probably you could have done better in a particular way in that idea which was there in your mind and you could have probably clicked with it. So I don't mean that you should go totally raw as an independent professional. I'm very certain you also, for example, Havish, have worked. You had a very awesome job in Reckitt. I remember it very clearly, and you were a really good paid professional, if I remember correctly. But so I believe even for you, the idea was to gain experience. So how I see it is gain experience, but make sure that you do something to meet your dreams. Do not let go. So that's what I can say. Just work hard, be passionate about it, and then God will somehow pave a way.
Thank you so much for joining in, Bharat.
Thank you so much.